preparing a brief. So I've actually written a blog on what do you do when a brief comes to you. Depends. I mean, if a brief comes to me, I usually like to talk to the briefing counsel or the party first. Because that way you can quickly get a lot of information by asking very pointed questions. But that's because I have less time. I would want them to proceed chronologically. आपके सामने client बने, ask them from the start. Then keep asking follow-up questions then and there, and then taking down the important points. If it's a criminal case, for instance, start by asking them क्या stage है case की. Something as simple as that. Charge पे लगा हुआ है, evidence पे है, या अभी complaint ही lodge नहीं हुआ. You'll have to ask them those things. Reading the FIR in a state case, the charge sheet, the order on charge, the summoning order, those are very, very important, obviously. For example, if charges have been framed in a criminal case, you straight away, because your time is less, quickly want to get to the point. Obviously, you spend a lot of time with clients and you have to. But at my position, sometimes the team would spend a lot of time with the clients and then they'll come and brief me. But let me for a moment become Manish, right? Some brief comes to Manish would first look at the case, try to understand. If criminal cases, so he would first of all, if it's an appellate case and we have to file an appeal, he would look at the impugned judgment. Conviction acquittal की जो judgment है सबसे पहले उसको देखेंगे. Then if it's a charge framing order, so in a criminal case, after the charge sheet is filed, then the court summons and then there is a charge framing. The court frames a charge against you, which is what? It explains the accusation to you. And then you plead guilty or not guilty and the matter goes to trial. Some people want to challenge that order also. The charges should not have been framed against me. Then you read that order because that is the order you want to challenge. So Manish would do that initial analysis, see what documents he has, quickly write to the client back saying these are the documents we don't have. If he can ask the court clerk to get some documents from the court, apply for a certified copy. He'll apply for the certified copy. You'll get a wakalatnama signed. He'll have a long conversation with the client to see what's missing. Then he would start looking at the impugned order and then see what are the grounds for appeal. कहाँ लग रहा है गलती हुई है. So then he would identify what is the evidence in the case and what is the law applicable. First of all, my advice is master the facts. Law is something the judge is under an obligation to apply even otherwise. Even if you don't tell him the law, he has to apply the law, right? Either way. Even if you tell him the wrong law, he is supposed to apply the correct law. So, nomenclatures are unimportant or irrelevant. You may file an application in X section instead of Y. That's not important. Judge has to apply the right law. But that doesn't mean you shouldn't know the law. The best lawyers know the law, right? In fact, the only person in which ignorance of law is pardonable is the judge. Because he's decided for good or for bad, then you have to deal with the order. So, but facts are very, very important for most cases because that is where the judge expects you to be right. Because facts are yours, your clients. Law is something we can all work around. So they spend a lot of time on the facts. They were doing the 376 case recently. They were assisting me and 10 साल की सजा हो गई थी trial court से. It was a case where the girl and the boy met on Facebook, on Tinder. And the guy was a married guy. They met. The girl's allegation was that he got my consent for sexual intercourse on the promise of marriage, that I'll divorce my wife and then I'll marry you. According to us, the facts were otherwise. She knew that he had a wife and 2 daughters, and there was no such promise. So that was our defense. We prepared, we looked at the evidence, every witness's statement. Criminal case where you'll have the witness giving 161 statements to the investigating officer. The victim's 164 statement is also going to be recorded. You look at that very carefully. Then you try to see inconsistencies. Complaint में क्या बोला, 161 में क्या बोला, 164 में क्या बोला, बाद में examination in chief में क्या बोला. इन चारों के बीच में inconsistencies आप ढूंढेंगे. तो ये सारी चीजें करते हैं on facts. ये भी देखते हैं कि ऐसी कोई evidence जो ला सकता था client अपने defense में नहीं लाया. क्योंकि appellate court में भी आप request कर सकते हैं that please send the case back for me to introduce that one witness. So they looked at that. So very, very close reading of every page of the file is very, very important. Talking to the client. If your client is in jail, spend as much time with them. Don't house yourself in the jail for that reason. Go meet him in the visiting hours, preferably. And because sometimes that's not something we do. We're busy lawyers. That's a very small window, 3 to 5, where you can go to Tihar and meet somebody. It's very difficult. You have to wait for some time. But I try to make it a point even now that I go and meet them. Because they would tell you things which your briefing counsel sometimes may not be able to, your team may not be able to gather. Spend time with your clients, and that's also good for your practice. You're a dependable lawyer that they have. You're giving them time, which is the most precious thing. So do that, and then of course once you are okay on facts. So what we do is we do a timeline in a criminal case. We start at the start and then we walk down that road. Okay, कहाँ पे है? 8:15 बजे कहाँ पे हो रही है? हयात रेजेंसी होटल में, यू नो एट आर.के. पुरम के पास. कौन कौन है वहाँ पे? कितना समय हो गया? उस समय 7:15 बजे अंधेरा हो जाता है कि नहीं उस महीने में? यू नो हम इस तरह की बातें करते हैं सारी, क्योंकि फिर आप ट्रांसपोर्ट हो जाते हो. फिर जब आप बहस कर रहे होते हो उस केस में तो आपको चीज़ें दिख रही होती हैं अपने सामने. यू नो you're not hallucinating, you know, you have a picture in your head and you've read the case so deeply that it is vivid, it comes alive. And that's the kind of preparation that really works wonders in the court, because you know things and then you say, okay, how did it move? Timeline is very important in a criminal case, because most cases maybe you'll get an acquittal on the basis of timeline.